Okay. The musical interludes are a great addition to the Stigler Conference, by the way. I just want to say it's exciting to have hip hop here in the hizzy. So I'm David Dayen. I'm the executive editor of the American Prospect, and I want to thank Filippo as well as Luigi and Guy for another great conference once again this year. This panel is the first on AI, although it's sort of been an undercurrent, I think, on some of the other panels. Nothing in the world is really positioned as needing regulation more than AI, not only by governments and regulators, policymakers, including the two law enforcers we heard from yesterday, but within the popular culture, going back to like Player Piano by Kurt Vonnegut from 1952. I think that's because we become so fed by that popular culture that we can't disassociate intelligent machines from the belief they will take over the world and kill us all and enslave us, or just make us bored, which is the subject of Player Piano. But since my friend Matt Stoller was nice enough to quote me yesterday in a panel, I'm going to return the favor and quote something he said to me recently about the idea that regulation of AI is kind of a misnomer. I mean, as Matt said, it's like regulating the wheel. The wheel was an important invention, a labor-saving device, but we don't regulate wheels. We regulate cars that wheels are on. We regulate airplanes that wheels are on. AI is a tool, similarly. It's a technology, it's a spreadsheet, really. It's a big spreadsheet. We don't regulate tools necessarily. We more regulate the companies that are fated to create control and profit from those tools. Or to say it better, we already regulate the companies that are fated to create control and profit from this particular tool. We have laws against consumer fraud. We have laws against anti-competitive behavior. We have laws against product safety, laws against unfair and illegal pricing. We have laws against exploitation of labor, laws against violations of civil rights, laws against corrupting elections, laws against international war crimes, and so on. And there is no AI exemption from those laws. And so by way of framing the discussion outside of what the title of the panel is, that's kind of one way I think about it, but we will use this panel to talk about the laws we have, maybe, the companies that are poised to develop and deploy AI technology, and what they might or might not do that might or might not be of concern to regulators. So we have a good panel here able to do that. As you've gotten used to, each panelist will have a few minutes, maybe no more than 7, to start out framing the discussion. And then we'll talk amongst ourselves, and then we'll go to the audience. I'm going to try to get a lot of time in because there's obvious interest in this subject. So I think we will start with Joshua Gans, and the floor is yours.
Thank you very much, and thanks for inviting me today. Let me start with disclosures, because I think it was called for yesterday, but no one seems to be doing it. So let me tell you who I'm for and who I'm against. I'm in terms of paid capacity. I'm against Meta. I'm against Google. I'm for Amazon. I'm slightly for Microsoft, and I am for the Department of Justice recently. So I'm also for Apple, but I'm not paid by them. But I act as if I am. So I've had a long-standing interest in artificial intelligence. We encountered it back in 2012 at the University of Toronto quite early. It was coming through startups, and it piqued our interest, my interest as an economist, of what it was really about. I was somewhat surprised to learn that all of the recent advances, all the way up to the present day, were all just an advance in computational statistics. All AI does currently is do the statistical act of prediction. It just does it so well that the potential applications are moving beyond things we currently predict to things we haven't thought of as prediction problems, all the way from self-driving cars and now obviously to language, being able to talk to computers. The regulatory environment is properly characterized from my perspective as bizarro land. Everything, I come from an economics of innovation background, a competition policy and antitrust background. And the one thing that I always took for granted was innovation is good and we want more of it. And we want new innovations to be distributed and not held up by anything, really. And so we work very hard in competition policy to reduce monopoly power and gatekeepers and bottlenecks, as we saw in the last thing, so that we would accelerate the rate of innovation. Along comes artificial intelligence, and especially in its most recent incarnation, where it started doing things that, let me put very bluntly, the journalists thought that they could do. That it got a lot more notice and a lot more concern. And add to the mix that it's not called computational statistics in the general public, it's called by everybody artificial intelligence. We can now pair that with Terminator 1, 2, 3, 4, and 5 and decide that it's maybe going to destroy not only our jobs, livelihood, misinformation, children's brains, but also just the whole world. So that has created an environment where for the first time that I can ever remember, that regulators are explicitly coming out and saying, we want to slow down. We want less adoption. We don't care if it slows the rate of innovation because we're not sure we want this stuff anyway. And so all of a sudden, all of the things that we thought were the costs of regulation have been turned by regulators now to be considered a feature, not a bug. I don't actually think the basic economics of regulation have actually changed, but this attitude seems very, very new and is pushing quite forward. And it's having an effect as well. It was discussed earlier about foundational models and foundational models availability. And we have foundational models came from exactly where we thought they'd come. They came from Google, they came from Meta. Then they came from a startup, OpenAI, which everybody, because Microsoft's its biggest provider of cloud services for that purpose, now say is Microsoft. Apple, until literally a month ago, never ever mentioned the word artificial intelligence. You could not find it on their website. But now they've sort of been brought into it and we don't know what they're doing. And then we've got some startups. We've got, along with OpenAI, we've got Mistral in Europe, in France, pursuing these models. And we've got another startup, Anthropic, whose LLM is currently on the technical characteristics. It's an LLM called Claude 3, is the best currently for this month. It may change in some period of time, but right now it's the best. It's measured the best. Everybody who's used it realizes it's the best. I have and tried it. It is not available. It's available in over 100 countries around the world, including, of course, the United States, including the United Kingdom, including most of Asia, most of Africa. It's not available in Iran, North Korea, China, Russia, Canada, France, Italy, Germany, Belgium. Now, what's going on there? What those other countries have that's different from the United States and the UK, I'm going to put down as a different regulatory regime. There's no reason why you wouldn't turn on an LLM to be available worldwide. Everybody else has done it. It might surprise you to learn that Google's LLM only became available in Canada a month or so ago. It was not available for an entire year. So can regulators slow down adoption? Yes. Why and how and the mechanism by which that happens, I'm still perplexed. I don't understand why why this lack of availability is happening, and I'm unable to get a straight answer out of anyone on that front. And by the way, it must be bundled up with the press, because no press reports about this. You won't find a press report about Anthropic in Canada. But there's plenty of celebration when they hit the top in the United States. So this is what's going on, and this is the current regulatory environment. And as I said, it's bizarro land, and there's really no case for it. At present, all of the things that we've seen from these current generations from AI in general have been positive. I know there's discussion about misinformation and deepfakes and other things like that, which are of concern. That's one level of it. But everything else has been positive. There's been jobs have not been shed necessarily. You can be identified at. A few companies tried to sort of do it, but it's not clear how to play out. Any other harms and other things have not emerged. In other words, it is a unspecified fear that is driving a regulatory response that can be effective. And so we have to sort of look back on that and say, what's going on here? And what is the best way forward in this environment? Which is why at the moment I find myself a regulatory economist at heart, sitting there on the side of saying, this is crazy. Let's let it go for a bit. Everybody watch what's going on. That's a good idea. Let's monitor this situation and be prepared to act if there are bad things. But trying to jump the gun seems extremely premature, and there are all sorts of consequences happening in a market that's very, very much. There's some celebration about how effective AI is. But just like we had that initial hit with Google back in early 2000s, we're going to laugh at what we've got currently. It's not where this is ending up. So it's an odd thing to be concerned about. I think that's my sense.
Great. Thank you. We'll go to Ellen Goodman from Rutgers.
So great to be here. Let me start with some agreements and disagreements. AI is not a wheel. It is, I think we've learned, and I've been coming here for 6 years. And in that time, I think we've learned something about the digital economy and the regulation story. And so, we know that there are network effects. There are features of data collection and data use that make it, I do agree, AI consists of just, predictions and software and, code and chips. And so, it's made of tractable things that we know, but it operates in our world not like tangible items. And so that's one thing. And then, I think that the perplexity, that Josh, you have about the regulatory approach. First of all, I think we should be clear that we're not just talking about large language models, but also about narrow AI. And for the most part, narrow AI is what is in use and is causing harms. And those harms, though, I think you're quite right, Josh, that and David, that those are being addressed and need to be addressed in the verticals. So I think with respect to the question about should regulation focus on deployment or focus on development, for the most part, I think in the U.S. regulators have it right that it's mostly a deployment story. But I will in a few slides sort of address where the development part might come in. But this question of Josh, to your perplexity about kind of the energy right now behind the interest in regulation, I think it's not a fear of innovation, but it's this collision of the innovation story that we've heard before with this post-neoliberal understanding of power and concentration, and that is just, and I think a couple of people have mentioned this in their presentations, that the sort of data and compute that's necessary, especially for the large language models, is likely to increase, not decrease, the concentration harms that we've been talking about in this conference. And then I guess the last thing I'll just say as a stage setter is we haven't talked a lot in this conference about sort of democratic deficits and information harms. And I thought it was notable last night in the colloquy with Jonathan and Lena that when Guy asked them about, sort of non-commercial speech, they both passed. For good reason. It's not their domain, but that is a lot of the energy that's behind, I think, some of the regulatory fervor, which is mostly polemical at this point rather than actually grounded in regulatory action. So with that, let me just, just sort of set the stage on kind of where I think the regulatory story is right now. So AI policy in the U.S., and I think it's to some extent true of the EU AI Act too, is developing around opportunities and risks, and in some ways they're mirror images of each other, right? So of particular interest to this group are threats of dramatically increased concentration of power because of data and compute. There are arguments that there are also competition gains to be had. We've heard a lot about, with respect to narrow AI, of discrimination harms. There are also possibilities of overcoming a lot of discrimination harms and producing less biased decision-making systems. So I won't go through all of these, but if you look at the AI executive order that the Biden administration issued on Halloween last year, it is structured this way. How can we have AI policy that produces, that sort of gets us these good things and minimizes the bad? And, in terms of the wheel argument, it's exactly, I think to the extent that it is a wheel and what you need to do is regulate the car. Turns out DOT is doing that with respect to AI in transportation systems. FDA is doing that. SEC, FTC, EPA, they're all kind of, regulating AI outputs. I would say a challenge to doing that is that there are problems of measurement, there are problems of opacity, and there are problems of government capacity in even understanding these systems. So I think when I think of, I think we're talking about, this panel is entitled AI regulation, but I would encourage us to sort of use AI policy instead, because I think there are sort of three buckets to think about kind of mitigating these risks and gaining the opportunities. One is ex ante regulation. And so are there certain applications that should be prohibited, that should meet certain minimum standards? Should they protect human rights in new ways? Are new rules needed? Also, with respect to ex ante regulation, are there ways, and we very much can look at the model of the SEC and FDA regulation, that regulators should be performing information forcing functions to create more efficient markets in AI and sort of help deployers understand, what systems that they don't have much visibility into, what their capacities are and their limitations are. Second bucket is subsidy and support. And so, we have heard in this conference a lot about DARPA, sort of DARPA projects that got commercialized, R&D investments. And so there's a lot of thinking about what kinds of AI capacities and infrastructure, really, sort of compute and data do we need government investment in? And then finally, the third basket, I think, is kind of market making, the ways in which government, especially the federal government, can use its procurement power and establish best practices through grants and contracts. And the recent OMB guidance is a step in this direction. And I was interested to hear yesterday about the impact of defense contracts on IBM patent licensing. So there are ways in which there's a kind of subterranean government policy, market shaping force. Okay, so this is one depiction of kind of the AI life cycle. I have these there are some entities or AI actors that don't quite fit in here that are floating on the outside. For example, users, right, who are using deployed systems, auditors who are coming in to audit or re-audit evaluations that have been done. And so I think, and I've also listed sort of a lot of questions that we might ask about AI systems, pre-deployment, post-deployment, with respect to mostly this is risks. And I think, there is a consensus that to the extent that there is new AI regulation, that it should be risk-based, right? So there's developing language to talk about what kinds of AI systems are high risk, but essentially it all centers on those that affect human rights, civil rights, and security. And those that don't really, we can sort of put them aside. But to say that regulation should be risk-based doesn't answer the question of whether it should be vertical or horizontal, right? So to the extent it's a wheel, it should probably be vertical. And horizontal, though, I'll say something about that in a second. Now, nor does it, to say it's risk-based, answer the question of where in the life cycle the intervention should be. I think as a general matter, there's probably a consensus that regulation should impose, to the extent that it's warranted, should impose responsibility with the entity that's most able to avoid the harms and deliver the benefits. And for the most part, that is going to be the deployer who knows the context in which the system is deployed and what the risks are and has the most control. The problem with that is that the deployer may be missing important information. And so there's an interesting bill out of Colorado that sort of creates presumptions and safe harbors based on information that's for the developer, based on sort of milestones they have to meet or certain kinds of, I'm making it sound more complicated than it is, but just based on information they have to disclose based on their own sort of risk assessment and testing to the deployer, so that the deployer, has some basis for making that assessment and calibrating the risks that they want to take on. Okay, and I guess the last thing I'll say about regulation in general is that a lot of the questions that are being posed really, things we need to know in order to mitigate risks have no purchase in existing law. Mis and disinformation is an example, right? We don't have any existing law, and the First Amendment is obviously a serious constraint here to how we might deal with that problem. I think the other sort of general thing I neglected to say is that, another explanation for the fervor, right, around this sort of we got to regulate AI is because, we're emerging from 27 years of a kind of regulatory desert with respect to digital, right? So Section 230 has, sort of prevented any ordinary development of liability regimes for the most part, with some exceptions for, digital platforms. And I think people are not happy with the results. And so, there's a sense, I think, in policy circles that this is a chance for a do-over. And are there places to intervene early? It's a separate question about how how Section 230 might apply to generative AI. But I think that's the sort of tenor of the discussion. Okay. So just to conclude, or this is my penultimate slide, with kind of how regulation might fit in to limiting AI risks, where they exist, and I think they do really clearly exist. I mean, we have countless examples of automated, and whether it's called AI or just an algorithmic system, of harms of discrimination, due process, obviously privacy violations, right, which is a whole separate conversation. And that is the kind of regulation that really does have to be horizontal, right? It's a kind of missing piece of the whole regulatory structure, and you're not going to have each vertical having their own privacy laws, although, we have some of that too. Okay, so I think of regulation as one of three major levers in limiting AI risks. But it's sort of policy tools can make each of the levers work better, even if they're not centrally concerned with policy. So, for example, if we want competition in AI tools that are privacy protecting, fair, non-discriminatory, widely dispersed in a competitive environment, we might think about what policy tools we need to facilitate that besides antitrust law. And so, we do have a lot of examples of regulatory information forcing functions. I mentioned some of them: SEC, FDA, USDA. If you think about, sort of organic food or, source of origin labeling for meat, et cetera. We also, if you want strong markets, you might want, as we have in the financial system, audit standards. Support for standard setting, which right now is way behind where it needs to be. Model and system card disclosures. So there are now system cards, but they are completely incomparable. So, Meta releases its system card and Google releases its, and you want to compare large language models, and they're not very useful for that. On liability, I mentioned that the liability space in digital has been deep frozen. In software, liability regimes have been very lax. And that's just because customers have disclaimed liability. And so customers and users have borne most of the costs of software failures, especially security failures. So the Biden administration's cyber strategy seeks to create new liability standards for software. And since AI is mostly software, that would have an impact on AI as well. And the goal is to get companies to take reasonable care. There are a lot of other places, if we expect liability, ordinary liability, or new forms of liability to sort of do the job, I'm almost done, of mitigating AI risks, there are policy interventions that will make that work better. Information, also creating safe harbors to encourage risk management. And then, we've talked about regulation. So finally, the last thing I wanted to say, and this is a bar chart that shows kind of the distribution of the tasks in the AI EO. And they don't, the numbers don't necessarily correspond to priorities or the salience of those tasks. But what's interesting to me is how much that first bar is government AI talent. And then if you also bundle that with immigration and some of the other sort of government focused, we need to get our shit together tasks. And I think what that's saying is that, there's no balance of power here with respect to both the infrastructure needed to sort of run and interrogate large language models, and also the know-how, to the extent that we want. Yes, we have consumer protection law, but like the amount of skill that's necessary to interrogate how AI is being used to hurt consumers is something the government's really going to have to augment. And then the last thing I'll say that I think is interesting here, it is towards the bottom, but there are a lot of tasks concerning synthetic content, which I know Matt and I are both working on. And so, this goes to this anxiety, and it's an anxiety in government about authenticating content, distinguishing AI generated from altered content. I think from the government's perspective, it's about security. It's about the utility of government disclosures for the functioning of markets, right? And so, and for democracy reasons, there are lots of other reasons to sort of want some sort of data provenance on the training, and sort of a provenance of LLM outputs and supply chain tracking, also for copyright and IPRs. And so, I think this is something to watch. There are complicated free speech issues, human rights issues, and just basic efficacy issues around watermarking and provenance. But it's an example of a place where we don't have an agency doing this. We don't have existing regulation, and there are sort of new concerns that that will run through the bloodstream of AI. Thank you.
Thank you. I'm going to go to Matt Perault now with UNC.
Thanks so much. I'm Matt Perault. I direct the Center on Technology Policy at UNC Chapel Hill and also have a consulting practice where I work with companies and organizations on a range of issues, including AI. Thank you so much for having me today. Thank you, Filippo, Rachel, Sebastian, and Brianna for making it possible to be here. I've been to this event in the past. There are a lot of familiar faces here. It's very nice to look out and see those familiar faces. I think it's a testament to the kind of community you've created that people come back year after year to participate in the discussion here. I'm super excited about this discussion. I think we have a lot to talk about. To Josh's point, I agree that I think we may be in somewhat of an uncomfortable place in terms of regulation, but I think we know why we're here. We're here because of a set of arguments, I think, about risks associated with AI. A thing that I have focused on recently, and I think it kind of goes with the title of the panel, how to regulate or how not to regulate AI. How not, I think, would be a position of regulatory humility, where we're in, this is the week of Passover, we're in a reclining position with respect to regulatory activity. I prefer a term more like regulatory curiosity. How can we lean in and gather information about where we are, about the harms that we're seeing, and then make smart evidence-based decisions about the right regulatory framework? So I think we know why we're here because there are a set of arguments that are made about why AI might be harmful. Our center did a report on AI and political ads, and the first thing that we did as part of that report was just to catalog the arguments that have been made. And I think the arguments are pretty clear. AI and political advertising will cause harms related to misinformation and scale. Misinformation will be produced at greater scale than ever before. Harms related to authenticity. AI content will be more authentic, and therefore misinformation in AI-driven misinformation in political ads will be more impactful. Harms related to personalization and harms related to bias. And then we tried to look at the research around those harms to evaluate what the research says about are they likely to be harmful or not. For those first three categories, authenticity, scale, and personalization, our assessment of the literature, and we may be wrong, you can tell me why you think we're wrong if you do, we thought the assessment of harms, the allegations of harms are likely overstated. That's primarily because political ads are actually not particularly persuasive. So it's sort of commonly understood in the social science research community that political ads actually have a relatively limited impact on what people think. They have more of an impact on how people behave, but from a persuasive perspective, the impact is relatively limited. We did find a few areas that we thought the harms were properly stated or understated. Harms related to bias in political advertising, we thought are properly stated. There's been a lot of conversation, obviously, about AI and bias generally, somewhat less, I think, in the context of political ads specifically. That's something where we think policymakers should really focus their attention. And then in smaller and down ballot races. So the day that we released this report, it was election day this past year, lots of conversation about whether X's policy with respect to misinformation and political ads is going to affect Trump versus Biden. I think the research suggests, again, we may be wrong about this, but the research suggests, I think, that those concerns are probably overstated. But on that day, Election Day 2023, I voted in Durham, North Carolina City Council race. Down ballot races like that one, I think, are areas where there could be more disruptive impact from misinformation and political ads. And public policy now is really focused on the big federal issues, not very focused on the small local ones. And I think that's probably not properly calibrated to the literature. So that's the arguments, research about the arguments. Based on that, what might we think about policy frameworks for addressing them? And the thing that I come back to over and over again, and again, I'd love feedback on why this is a silly recommendation. Elettra, I think the title of your paper, which I have not yet read the paper, but I was intrigued by the title about experimentation, experimentalism. That's the concept that I've come back to over and over again. We are at a point of stasis where often, at least at the federal level, less true at the state level, we do not pass laws. And therefore, we are unable to gather data about what policy frameworks work and what don't and why. There's the question, I thought it was an excellent one on the last panel, how do we know if the Digital Markets Act is working or not? We should have feedback mechanisms. to help us evaluate whether it works or not. My understanding from a wonderful discussion that Christopher Yu and Gene Kimmelman had at the Knight Inform conference in Miami in January is that there are actually some built-in evaluation tools for the Digital Markets Act and offices within the EU that are studying impact that will provide feedback, hopefully at a granular level on things that are working and things that aren't. That's what I think we need as well in areas like AI, where I think we all can make assessments about what we think the likely impacts are going to be. You're alluding to the potential impacts on innovation. I'm concerned about that as well. It might be that you and I are wrong about that. The way that we will determine, I think, whether we're right or wrong is based on gathering information and making assessments. So what could an experimental framework look like, or what are the elements of experimentation? I think it's time-limited policy trials of some form, so they don't go on for infinite duration. Some sort of liability protection during that time. I know that's a disfavored idea generally these days, but I don't think that you can have experimentation if platforms bear a lot of risk for that in those experiments. We actually have liability protection and experimental models and things that are far more important than tech policy, like clinical trials in medicine. We have COVID vaccines because we tested in this incredibly important area to see if medicine would work. We have vaccines as a result of clinical trials. Tech policy, I think, is less important probably than that domain.
Then the liability protection goes away at some point.
Sure, right. So that's exactly it. So an experiment is a time limited duration. And so in that time limited period, you would have liability protection. Once you then hopefully make, smarter public policy comes out of the experiment, where there's liability protection if that's a good thing to do, but presumably there wouldn't be. But it would be how you design the policy regime is informed by the experiment. And then in that period, you have auditing and transparency. So you don't just conduct. One of the things, I generally like the regulatory sandbox model, but one thing that I think is frustrating about it is there's not a lot of evaluation I have found in doing research on this on whether they work. What are the impacts? Who's harmed? Who's benefited? That's what I think you need in an experimental model to gather the data to then move forward and create smarter, stronger policy regimes.
Great, thank you. And then we have Tano Santos, who was a late arrival to this panel,
Yes.
but a valuable one. So,
Thank you very much. It is actually my first time in this conference. I've never been invited before, and the reason is because I don't do anything related to antitrust in my research. I'm a very broad economist, but I've never been here. So thank you very much for the organizers. Thank you very much to all of you for being here. So David asked me to reflect briefly about AI and regulation of AI in finance. Financial markets and the financial service industry is a data-rich environment where, the application of technology has a long tradition for obvious reasons. So it's a good place to look at when thinking about what is that we could expect in terms of AI in the economy at large. So I will report on a couple of things about that, both in banking and in asset management, and perhaps that can shed some light on some of the things that we can expect from the deployment of AI in our economy. And I cannot resist the temptation actually to make a comment inspired by some of the things that we had in the previous panel about DMA, but also some of the things that came up in yesterday's very interesting panels about AI and one of the regulatory challenges that I think is going unaddressed. So let me start with banking. So banking, for obvious reasons, has been applying all of these tools in order to solve standard problems in banking that go from fraud detection, for instance, to underwriting, whether it be loans or insurance policies. And we already have a lot of evidence of what it's doing to competition in banking markets. There was a very good paper this year in the market by Naz Kunt, who is going to Stanford, basically documenting what this technological revolution is doing to markets for deposits, markets for loans. And what you see is an increase in competition for local banking markets. So what you see is entry, what she refers to as branchless entry, by which mid-sized banks, mostly not the mega banks, supply banking services in small local markets until they're only serviced by that local small bank with 3 branches in that county. This actually has an enormous effect on consumer surplus. Most of the welfare gains associated with this technological innovation are accruing to consumers. Are they an equal distribution across consumers of this revolution, mostly accruing to high household incomes for reasons that we can discuss? They get better rates on the mortgages, they get high rates on the deposits. So in that sense, it seems to be a force for good. on what we would expect technology to be doing. One of the interesting things when looking at this evidence is that one has to define the market for, in this case, banking services carefully. So and this actually speaks to some of the things that Giovanna was presenting yesterday in the very first panel of this conference, that if you look at the shares of banks in the local markets, those are going down because you have a lot of entry by mid-sized banks into these small local markets, whereas the national shares are going up. So the way we want to assess the impact of technology on what is going on in competition in many of these markets is going to depend on the definition of the market, and that's incredibly careful when it comes to services, which, as you all know well, mostly are supplied at the local level, even though some things are taking place there that are interesting. In terms of, so, by the way, going back to something that David started with, this thing of whether we should regulate the wheel. What you worry about is whether, the application, say, of artificial intelligence to loan underwriting is going to result in, say, bias, whether we're going to be indexing loan underwriting to characteristics that you're not allowed to use when assessing the risk of the borrower. But there are ways of solving this. You don't need new regulation on AI to solve this problem. Whatever the bank is doing in terms of underwriting is already under the existing legal framework, and you should make sure your algorithm is not indexing underwriting standards to private characteristics. And there's a way of doing this, and we can talk about that. In asset management, the news are not good. We have a long tradition of applying, software broadly understood to trading. I grew up in the early 90s listening all about program trading. We had a crash associated with program trading in October 87. Then the development of the quant industry, which is basically the application of these big tools to, strategies, big scalable strategies in asset management, in asset markets. We already had a crash in the quant crash of August of 2007. And it's not surprising why are we getting these problems of systemic stability in the application of these tools is because they induce correlation in strategies. Now, one of the things that is interesting is that when you actually look at the say the crash of 87 or the quant crash of 2007, you can go back and figure out what happened and then charge the appropriate risk weights so that those things do not happen if you think there's an externality associated with those crashes. It's going to be very difficult to do with artificial intelligence. And the reason is because when you're dealing with, say, a deep learning model with billions of parameters, you just have no idea about what kind of correlation structure you're inducing by the spread of these methods of trading these assets. Just it's very difficult to know. And the same way we have hallucinations when we do these things with ChatGPT, just imagine the type of hallucinations we're going to have in financial markets when these companies go. We already have enough of those hallucinations in financial markets, so it's going to get even more fun. So let me finish with just one comment that is nothing to do with finance, but that it struck me as I was listening to some of the discussions we've been having over the last day and a half. When I think about AI, the key thing of AI on, say, a deep learning model, a neural network, or something along those lines is that, those models need to be trained. And training requires data. Data is the ultimate non-rival good. And when you think about non-rival goods, at least as an economist, I think issues of ownership recede to the background and issues of access move to the front. And then the question is not so much whether you're going to be allowed to run your application on a platform, but whether you're going to be able to train your model on a data to which you don't have any access. And the question is what, and this is a question for the people in this audience who are law specialists and who know 10 times more than I do about these matters, is what is the legal framework that you can use in order to guarantee access to particular data in order to train models and guarantee, say, product or service market competition. And, it seems to me that this is completely open. I realize that, I don't know the name of this. I think I learned in a Becker homework problem. I think it's called something like the essential facility doctrine or something like that. It's a moribund doctrine in the United States, but it's actually alive and well in Europe. And there are constant references to it by the European Court of Justice, who has a tradition of actually granting access to entrants to the protected, for instance, IP of an incumbent, provided some particular requirements are met. And one wonders whether, when it comes to AI, granting access to data in order to facilitate the training of models to guarantee product and service market competition may be a good idea. I'll leave it at that.
That's great. Thank you. I want to stitch 2 points together, the one that you just said, and also Ellen's, I think, very good point about the fact that, the potential overcompensating because we've been in this regulatory desert. I think to add on to that, it's not only been the fact that we've had these outcomes in digital, but it's the same companies that are poised to thrive from AI that are the ones that there is this perception that we haven't gone far enough with. So, and that's because they are the ones with the greatest access to that data, right? And so putting those two questions together, maybe for Ellen and others, how do we set up a regime so that there is some competition here, so that it isn't sort of an inevitable circumstance that the companies poised to benefit here are the same companies that are entrenched because they have the access to the data. So, and just to add an additional provocation, I mean, Tim Wu, who I guess is not here, yesterday said, should a remedy in the Google case be that you can do everything you want, but you don't get to do AI? Anyone?
So I think that question comes up. There's a funny anyway, sort of mixing a lot of things. I mean, one thing, and I think has been made clear, AI regulation is like all over the place in terms of instruments, areas, stuff like that. One of the reasons it comes back to competition law is that competition law, they're the one place that's decided that the big tech companies currently doing AI are the bad ones. So that's where we can maybe use those instruments. And I feel there's a bit of that going on here. But there's also this other aspect. We've been around a long time. Some of these people, I've moved in this conference. I used to be a young person in the conference saying, let's whatever, we can do whatever, just use economic theory. And I used to listen to the very old people saying, the world's hard. And so I'm in a transitionary state going on in that regard. And you recognize it because it's basically this sort of like, what should we learn from history? And we've learned from history that, and Tim Wu wrote that great book, is that, in telecommunications, digital space, computers, whatever, that broad information markets, we've had a sequence of serial monopolists going on throughout it. And, and people look at this and say, we've got AI. And they look at the people who are jumped onto that the earliest, and that was the big tech companies. Susan Athew's chief economist at the DOJ antitrust division at the moment was previously the chief economist of Microsoft back in 2008, 2009, going on, and noticed AI before any of us did in the economics profession right then and there. This was happening right then and there, and noticed it in the research coffers of Microsoft going on. So it's been going on a long time, and now it's having its moment. And it's very easy for us to say, look at who's doing this. And let's look at the scale, in particular, of the foundational models. $1 billion, $10 billion, $100 billion. Some person running around saying $7 trillion. I mean, in terms of investments, that doesn't open us up to, that's going to be a perfectly competitive market. That doesn't sound like that, right? And so we say, let's learn from history. We've seen this script before. Let's intervene now and see what we can do, which is exactly what you alluded to. And what do? We focus on what are the advantages. Why is it that the big tech companies have this? They have the data. AI needs data. It's a statistical process. Finally, we're going to admit that. And it needs data. And these guys have the data. So that's where it should be unlocked. And we saw a very neat discussion yesterday that some of the things that would unlock it is using the copy and paste function to take the database and move it to other people so they can use it in essentially according to its non-rival flavor. That makes huge sense to me. I just wrote a paper on market power in AI. If anything that we can learn from that is it's getting the data fluidly transferring amongst things, a form of interoperability, if you will. That would be one thing that we could do. And it's the one thing no one will talk about doing. Why? Because of privacy, another value, comes head to head against it. and especially in Europe. So up there on Fiona's slides earlier, video sharing. That was by far the most important thing in that list. The YouTube was done. Why? Because YouTube have all the data to be able to create AI videos and video content leading to misinformation, deepfakes, and everything else. They have all of that. What's the chances of somebody, I'm an AI firm who's interested in doing movie things. Google are able to use their YouTube data for the training of their process. I should be able to use it too. Is the European Commission going to say, tick, that's a contestable market? Or is when Google stands up and says, well, there's privacy considerations, other things, and what's going to happen? So that's coming right then. And just as a final thing, Matt is 100% right on how to learning. Another thing I worried about, there's a big mindset out there that we can learn about the harms of AI in labs, in very small areas. But these issues that you've already identified, misinformation and so forth, are ones that are ones that really happen in the real environment, the marketplace. It's very hard to take an experimental result and work out what's going on. And it's very hard to know what the delta is on AI as opposed to everything else going back from misinformation. You know, back in 1969, they had the technology to completely fake the moon landing.
They did. Capricorn 1. I saw it.
They actually didn't, but that's I just
really?
wanted to see if I could.
I'm sorry, I'm very gullible.
Everybody say he's gone off the deep end. He's not just old, but we've had misinformation has been a thing for a while, and we don't know whether AI. You know, if you see little images come out now, you know that they're AI. Yesterday, Taylor Swift's album was released unofficially several hours before the actual release. The Taylor Swift fans all thought it was AI generated, which is a bit of an issue. It turns out not, which is an interesting critique going on there. But because people start to adjust. No, I'm not saying that's not disruptive and bad, but it's hard to know. Are we protecting democracy? Are we protecting information? Are we protecting existing incumbents? What are we doing?
Right.
Sorry.
I have just a table stakes question actually for you, which is the position that you opened the panel with was what do we need additional law? Because we've got all this existing law, and the existing law might be meaningful tools. I read the White House executive order positively in this regard by saying we've got tools and we need to do active work to use those tools. Yeah. I interned when I was in law school at the criminal section of the Civil Rights Division. The people in that section wake up every morning figuring out how to prosecute federal civil rights crimes. Those cases do not descend from heaven into your lap in a perfect complaint. You need to figure out how to make the case out. And the executive order, I think, will help that, the kind of coordination.
Yeah, it was a coordination function.
Right. Sure. So that makes sense to me. But then we've also described the current landscape as a regulatory desert. And that makes me think, well, we don't have sufficient law. Do we not have sufficient law, or do we not have sufficient will?
Or do we not have sufficient information? Because I think the most important thing in that particular executive order was this use, weirdly, of the Defense Production Act to obtain risk assessments and safety tests and all these things to get AI companies to give that information to
But only
government.
for models that don't exist yet.
Was it a grandfather kind of clause?
No, it was at a very high level of course we'll surpass it very quickly, but yeah.
But so then when we talk about a desert, what we mean is not laws on the books, but will and information.
I mean, you tell me. I think that the desert being described by Ellen, and she can describe it probably better, is about what has happened with whatever laws that we've had over the last 20 years, because we've had certain things in place that could have been wielded to counteract that. But Ellen, maybe you can describe that a little better.
Oh, well, the desert point I was referring to was liability because of Section 230, which was we've sort of had a frozen development of common law with respect to laws on the books. But it is also true that we've just been hearing about how there hasn't been until recently a robust exercise of competition law or regulatory jurisdiction. Can I Josh, I couldn't agree more with the points that you raised about
values in conflict. And I think I was part of a Department of Commerce NTIA project where it was on AI accountability and a lot of stakeholder consultation with, everybody, NGOs and academics and business and consultants. And, there were like the 2 points of most agreement were risk-based. Everything has to be risk-based, but also what is the values hierarchy? Because and I think if you look at the White House's AI Bill of Rights, which is a really well done kind of set of aspirations for how human and civil rights intersect with AI. They looked at that and they said, okay, but some of the things that the rights it wants to respect are in tension. And so, I think, taking your admonition to be humble, like looking at, I think, Josh, you suggested maybe there should be an to your question, David, about like, what do we do about data? Maybe there should be an unbundling requirement, but then that runs, we don't have any privacy law. Like which comes first, and what kind of privacy data protection law, how would that intersect with an unbundling?
Well, we can talk in the abstract about this, or we could actually look to Europe, where they actually have the first in the world kind of law called the AI Act. And I don't know how many, whether or not you've studied this. We had Christina, who was going to be on the panel, and I'm sure would talk for an hour about it. But what are your thoughts in terms of, that's more of a product safety law, as I understand it, rather than, certainly it doesn't touch any of the competition issues, but is product safety the way we should envision this, maybe, is the question.
Well, I think it's another conflicts one. You look at the European AI Act, and I don't look at it in a legal lens. And there are all sorts of sensible things, like, to put it in colloquial terms, like knowing what the algorithm does, knowing where the data came from, things like that. There are some, there's the risk assessment. In medical devices, you're going to have to do some better things. Of course, we already have existing laws for those sorts of things. But so there's a lot of just normal common sense things. The thing that I worry about, and it's the same thing that happened with GDPR and same things that happen whenever we're talking about innovation, is this now conflicts straight with the goals of competition policy. Because all of the large firms, we heard yesterday, half of Microsoft's desire or Google's desire to comply is to avoid bad publicity. Why? Because they got valuable brands. Even monopolists have valuable brands, believe it or not. And so they've got that. And so they're doing all this stuff. If anything, at the moment, there's more regulation of AI going on inside these companies than not, which has led to some recent obvious disasters. But I worry about the startups who can't do all this compliance. And I worry about that we're going to do analysis in 5 years' time and show that once again in Europe, the startup ecosystem has been demolished. It's way below its weight. And there was some last minute things just because there was a French foundational model coming in that actually alleviated a few of some of the constraints that might be. But that's what I worry about.
So if I can interject just 1 second about this. I think that one of the important issues about these conflicting values, right? We need to assign property rights, and those property rights of the data will result in a particular distribution of data in the population. And then it's
not cheap to do so.
It's not cheap to do so, but you can in principle forego some growth. If that's your value is that data is completely private and you don't want it to go anywhere. That's it. Sacrifice some points of growth or productivity growth, simply because you want to uphold that value. That's nothing wrong in economics that would tell you otherwise. It would be interesting to know, and I think the political economy problem is going to come, because the benefits of having that data broadly distributed are enormous, are just simply enormous. And to that, you have to add to your point before, Josh, is that, in a way, there are phenomenal economies of scale in data handling, in data collection, in data. So, and you already see this already taking place, that effectively data wants to flow to a few users, say Amazon, Google, and, it becomes a fixed cost for those players. And as a result, they need to have some pricing power and markets exposed in order to recoup the cost associated with those fixed costs, and it becomes a variable cost for everyone else. And you can already see this, by the way, in income statements. And it's just the logic of that is through this consolidation. Those are the economies of scale argument. You need to think about that and how you want to handle that problem from a regulatory point of view.
I mean, one thing I would say is it's not just that these incumbents have the data; they have the power to acquire it. There was a story in the New York Times about how Facebook considered buying Simon and Schuster so that they could digitize all of the books in the library of Simon and Schuster. There are questions of whether we're running out of data for some of these models, and there's data generation by AI that is being fed back into the AI. And there just aren't that many companies that are going to be able to do, buy a book publisher, for example. So, I agree with you in principle that there are benefits there, but it's about power as much as it's about access.
I think your opening gambit was a really powerful one. In that, I think you were making the proposition. I think it was implicit, but I think you were implying that when we go beyond existing law, we introduce compliance costs and other features that will be really challenging from a competitiveness standpoint. And that seems right to me. I don't think the status quo is going to be sufficient over a 30-year period for governance of AI. But I think your initial skepticism of what some forms of regulation will bring is probably right. I hear you also saying, like, we need real teeth to current law. It's not just on the books. We need enforcement. We need information gathering. I spoke to a general partner at a venture capital firm recently who said all of the portfolio companies, all the companies in their portfolio that are doing AI have two main fears. One is access to compute, and the second is regulation that will make it hard for them to compete. Mm-hmm. That seems right. I mean, that seems, I think, sort of consistent with your framing that going beyond the status quo, at least right now, has real risks. I think the question then is, do we get sufficient governance? Because that's one of the things we've all, I think, talked about is, like, there are trade-offs to whatever posture you take. Not going beyond the status quo probably also has some governance risk that we're a little more in the desert land than we'd want to be.
Yeah, please, Josh.
So let me just clarify just one thing. In terms of, what is our ability to create a future that has huge amounts of competition? My assessment is the likelihood of getting huge amount of competition or it looking exactly like it did for the internet of microprocessors and everything else is zero. I think we're going to look at it in 20 years' time, and there's going to be some big tech companies who are dominating the space, and we'll say, what happened? And just as we did back from the early 2000s and to today. But who will they be? So I'm going to make a prediction here now, because it's fraught with everything, is that I don't think in artificial intelligence it'll be any one of the current big players. They'll still be around doing stuff, but I don't think they will be the targets of our antitrust ire. The companies that are the ones who win and dominate these markets are not the ones who promote the new technology, who build it out, build the infrastructure and other things for it, but the ones who solve its biggest problem. Back in the early 2000s or late 1990s, we were already aware that there were going to be big players controlling the internet. And those big players were going to be Comcast or the various big telecommunications companies, and we spent a good decade regulating them to make sure that the whole thing opened up. They weren't any of these current names. They weren't any of these current names because Google solved the problem of the internet, which was to reduce information, reduce the information overload problem. It was the chief problem of the internet. They solved it. They won. I don't know what the chief problem of artificial intelligence is. I'm 100% sure it's going to have one. And I don't know who's going to solve it and what's going to do, but they will be who will be back here wanting to rein in 20 years' time.
That's a bold endorsement of the FTC and DOJ's cases against the big four tech companies and the remedy that Tim Wu is going to put in place that they can't go after AI. Just to respond to you, Matt, I guess where I'm coming from, one of the bigger pieces that we've done at Prospect on AI was about the National Eating Disorder Association, which had a union drive for their helpline, and they fired everybody and put AI in place to run the helpline. And the helpline then started telling people with eating disorders that they needed to get more protein and eat more. And that seems to me like a problem of the National Labor Relations Board to solve, rather than the problem of a new agency or whatever we're thinking about here. So some of this does seem to me like old wine in new bottles a little bit. But I'm certainly open to the idea that there are novel things here that we don't have covered by the current regulatory regime. And I'm wondering, and maybe Ellen, you can answer this question. Is there thought toward a new agency around this, or is it thought about distributing the various preoccupations to existing agencies?
Yes.
Both.
Yeah.
Okay.
Yeah, there's plenty of work being done on a new digital agency. I mean, this idea has been around for a while. And then there are a lot of advocates for putting a lot of this in the FTC and kind of muscling up the FTC. But you saw that the EO, and there's a lot of, there are a lot of bills for appropriations that would fund things that the EO can't do. For beefing up capacity in each of the regulators.
Great.
I think there's a passive version of the existing agency point, which is sort of like do nothing, no investment, no technical increase in technical expertise. And then there's a different version. And this is, again, what I liked about the executive order. I think what you're saying is it should be the National Labor Relations Board. And also they might need technical expertise. Mm-hmm. They may need to hire new 100%. People. They may need any 100%. Number of different things to build a strong understanding of what their law looks like in a world where AI may be used in certain ways to violate it. And that's not passive. That's active. That requires reward.
Right. And I know the FTC is hiring technologists at a pretty rapid rate, probably for this very reason, among others.
Right, but is the National Labor Relations?
Well, probably not. But there is a coordinating function they can conduct.
Can I ask Tano a question? So I don't know anything about banking or insurance regulation, but I did notice that Colorado has is the first and only seems to have a new law governing AI-based underwriting. And I just, I'm curious as to what your thoughts are about, did they need that? It seems to have governance requirements and risk assessment requirements, and also I think substantive limitations on the kind of data that they can use. I mean, do you think that's belt and suspenders, like we don't need those particular AI regulations, or is there something different about the use of AI that states will need to relook at their insurance law?
I mean, we haven't had yet a credit crisis or that is related to the use of these methods for underwriting purposes. So the answer to your question, which is very legitimate, is we don't know yet because we haven't had a cycle. We always have the same type of credit crisis of bad underwriting is typically associated with speculative cycles. If you look at the type of banking crisis that they're worried of, people like Anat, for instance, they are related to big movements in real estate markets, and those seem to be more related to agency issues than anything else. There's an issue that one would need to open these programs and understand exactly what they do, because one problem that the regulator is going to be confronted with is that even if you are not allowing that particular program to condition on your characteristics, say your gender, it's very easy to pick up your gender because it's correlated with many other things. And the question is, what can we do to actually make sure, those signals that you're getting out of that algorithm preserve the privacy of some characteristics that have some protection under the law? So that I don't know how well equipped are regulators right now to assess this, and maybe that's the Colorado regulation that is after. But that's going to be an issue that those programs need, because if not, you will end up conditioning on those characteristics. And the bank may be completely unaware of this, and that goes to your liability issue of who's going to be responsible for the fact that there's a Colorado bank that is excluding some borrowers on some characteristic, but they actually didn't know. Is the algorithm selecting because the algorithm was not well designed? Now, there are results in this field that suggests that you can construct those algorithms.
There's an active case that's very similar to that right now,
really?
involving what's it called, Rainmaker, which is an algorithm that helps resorts and casinos set prices, and they do it by collecting every single price and then saying you should raise them because you're not going to lose market share. But and then that is what the companies, Caesars and Resorts Internet, they have argued, which is that the algorithm did that. We didn't do that.
Yeah,
and so
exactly.
so these are some of the issues that from a legal standpoint, I think are going to have to be dealt
Oh, I
with.
mean, these
Exactly.
algorithms are going to be wonderful at picking up behavioral biases and exploiting them. They're going to be terrific at that.
Yeah.
And selecting people who are addicted to gambling. We already have these problems with many of these algorithms. So.
Yeah.
It's good that Colorado's got the law. That's an experiment.
Yeah, it's an experiment,
Right.
actually.
Good on them.
I want to get everybody in because I think a lot of people are waiting and want to discuss this. So go ahead.
Hi, everyone. I'm a political theorist from Yale University. So I've been listening to the conversation for 2 days. I'm here to learn mostly. But something that strikes me that I don't see on the table or in the toolbox or even, as a magic wand that you could use is the reform of corporate governance. So it seems like a lot of the problems that you're discussing may be baked in the incentives that are in the corporate governance structure that dominates the economy. So why is that not something that's could be looked at? Reform that would give more of a voice, say, to investors, but also to employees. So you would maybe avoid some of the problems like the shitification of products that we discussed yesterday, things like that. So why is that off the table?
Is it off the
You
table?
don't have the right people here.
It's like, so this is more a broader point. AI is that's why people like talking about AI. It's a good foil for a lot of these issues. It brings to the fore exactly that, and we saw a discussion yesterday on corporate governance. Why aren't we talking about it? Too big. It brings to a discussion of do we have the resources and the ability and institutions of society to retrain the workers who are replaced by AI in the future? Do we have that ability as well? Great question. But outside of the wheelhouse, what is the meaning of humans generating the amount of contribution they do to create artistic work? I mean, why is artificial intelligence creating artificial different work different from the invention of the camera? Which was also a tool, great questions, but sort of like from the economics lens, whenever we're trying to deal with the policies and the parameters with respect to AI, it's like we can't solve the big problem in society. We're just playing down in this tweaks of trying to make it consistent as a coherent policy. So the short answer is it's too hard.
Okay. Richard, you had your hand up for a while.
It's a simple question. A couple of years ago, at the Stigler Center, Tom Wheeler, Phil Verveer, and Gene Kimmelman wrote a report, Digital Platform Agency. And they rooted it in what they took to be two principles derived from the English common law, duty to deal and duty of care. And their claim was that existing regulatory agencies and existing approaches such as antitrust were not capable of handling a dynamic environment, promoting innovation. And at the core of it, with the principles, and then a sort of elite technocratic council that would make decisions that was very knowledgeable with the insiders. And I guess I just wonder about your views on that. I'm actually most interested in the principles, duty of care, duty to deal, but also just the idea of a sort of technocratic fix, which is what they've been both in the field for a very long time, and they thought that was the best way forward.
I'm familiar with that. I don't remember their technocratic fix. The sort of fiduciary duty and duty of care idea has been developed. I mean, Jack Balkin and Jonathan Zittrain and Danielle Citron have all sort of worked on that as a replacement for Section 230 and a way to create liability, as well as to build into a regulatory body. So, I think that's a really good idea. I don't remember the other part of it, but one of the things that is true of AI that's even more true of digital platforms is that at least with digital platforms, there was sort of a sense of like a good outcome, like what would be sort of reasonable care to get X. And I think we're behind that in AI. We don't even know kind of what is 99% of efficacy and prediction, is that good enough? Well, it depends on where the harms of the 1% failure falls and how that works. And it's different in different industries, and we don't even know how to get to measure the 99%. And so I think we're a few steps away from figuring out what a reasonable duty of care would look like. But when we can get there, and then of course it can be elaborated, but I see that more as a liability kind of case law development thing than an agency thing.
As Ellen said, I think that report, part of the motivation for it was concern about the effects of Section 230. I think Section 230 is not going to protect generative AI models for the most part. It may in some circumstances. It will be very fact dependent. But the definition of an information content provider, which don't receive Section 230 protection, is are you responsible for creating or developing content in whole or in part? So generative AI platforms will be responsible for showing in court that they're not responsible even in part for the development of the content in question. So they won't get Section 230 protection, I think, in many cases. And so my guess is some of the things that motivated that will sort of be taken care of by an existing liability regime. I think there are probably a range of different perspectives on this panel about whether that's a good thing or a bad thing. I think it's actually probably more problematic, but I think probably others think it's a positive thing.
So can I add one thing about this? I think to the issue of the duty to deal, for instance, I think it seems to me obvious that there are particular circumstances where you can go and force a party that has, for instance, data, as we were discussing just a moment ago, to allow access to another party who wants to train a model to provide a service that currently doesn't exist in the market. That seems to me that if the company that has the data, ownership rights over which are not clear, is not supplying that particular service, why wouldn't you actually enforce a particular duty to deal to increase supply for consumers? So that seems something that one should consider. Let's put it this way. It goes to Tim Wu's point about adjacent markets and stuff like that.
Sarah.
Hi, thanks for a fascinating panel, and I appreciate the learning from banking. I think it's really valuable. So I'm trying to figure out how to think about targeting in relationship to AI, whether you want to call it personalized pricing, personalized wages. I like to call it surveillance wages, but or targeted content. So I tend to go back and forth between seeing it as a social media issue, which AI turbocharges and not something unique to AI, hugely relevant to the democratic questions. The harms are not just consumer harms, but very much democratic harms. But sometimes I think it is an AI unique. It's not just turbocharging. There is something uniquely harmful about AI enabled targeting because the turbocharging really makes it mainstream in a different way. What is the current state of thinking on bans on targeting, as we have in banking, beyond the protected class categories, and what are your thoughts? And I say this at an antitrust conference because, of course, the two key tools of traditional American anti-monopoly are non-discrimination, bans on targeting, along with structural reform.
Got us.
I would say, so currently, this is a bad credential. I'm currently trying to grapple with that issue. I'm writing a book about artificial intelligence, and I'm on the bias and discrimination chapter right at the moment. But there's an actually interesting set of issues regarding the sort of technical thing of where we want to hit the analysis or regulation of AI for the purposes of leading to non-discrimination or any of the other values in that regard. And the computer scientists initially went and said, oh, we've got these predictive algorithms. We're taking data, we're coming up with prediction. Then people use the prediction. But what's the data going into the prediction? Does it, for instance, include data of which a group you might be a member, an observable member of, and stuff like that, which would lead to different predictions than if you didn't have that data. And they tried to come up with some ways of doing so. And some of the discussion about, does the legal system force you to discard that data or not? There's an alternative point of regulation, which is to say, don't touch that prediction at all. Don't touch what that's going on at all, but fix it after the fact. You make sure that, so when you've got a bail decision or a thing, some of these things, or a monitoring decision, you get a prediction that gives you some indication about whether there's an issue, then it's what you do with that prediction. And should you, when you use that prediction, have different outcome, different ways of using the prediction based on, again, the identifiable group you might be a member of and stuff like that. And it turns out that the second way part is the way to go. It's better to get the full information you've got possible. And then if you have some further goals of trying to advantage, disadvantage groups and other things like that, you use that prediction in all its glory in order to push that forward. And it's a technical set of results, and that's why I hesitate to do it here, but it's fairly compelling on that front. In other words, the core of all of this is is not to regulate the algorithm itself. That's sort of like, that's the bad thing. We should be regulating the decision. It's the decisions that are being made. Do I let someone to college or not? And what are the criteria? How do I use the data available to me? That's how it comes out technically, and that's not a satisfying answer at that point. It leads to a whole lot of, yeah.
If there are, we're talking about covering existing protected classes, not concerned about generally, or
well, it could be any criteria you want, so it's nice and flexible. But yeah, but if you were just thinking about existing protected classes, that would.
But I understood your question to be a deeper one about the construction of self with, being in a feedback loop with a machine that is, whether it's persuasion or and.
Oh, that's a lawyer rather than an economist. I didn't get that at all.
Yeah, and I mean, where are we on that? We're nowhere on that, because where could we be on that? Because I just think that. So what you're calling targeting is also the whole value proposition of some of these devices, right? Which is like, I'm going to get into your email so that I can write emails for you in your voice. And so the question is like, would that be an opt-in? Yes, but you can't use my data. Yeah, so we should need to be thinking about that. And that goes to data protection and like the underlying kind of what data can they have and what can they do with it.
Are we out of time though? I believe we are out of time now because we have lunch. So this was a fascinating panel. Thanks to you all. I came in having a lot to learn, and I learned a lot. So thank you.